Welcome to HOA Karen Patrol. The board picked the wrong week to play games. Karen shoved a notice toward my chest and screamed that my signature was not required for enforcement. "Do not touch my clipboard," she said, pulling it back so hard the pen clipped to the top flew off and bounced on the wet asphalt. I stood there in my driveway, my own driveway, watching a tow truck back up toward my sedan, with its amber strobes painting the puddles orange. The driver leaned out the window and waved a magnetic tow authorization placard at me like it was a hall pass. I checked my watch. I had 40 minutes before my shift started, and I could not afford to miss overtime. My name is on the deed. My mailbox is 10 feet away. This is Minneapolis, Minnesota, in a master plan community called Lakeview Crest HOA Incorporated, where parking rules are treated like sacred law, and the board thinks property lines are up for negotiation. I work as a warehouse forklift lead. I pull night shifts, double shifts, whatever they need. The overtime keeps my head above water, and right now my mental health has been fragile, and the harassment is pushing me to the edge. I cannot have my vehicle immobilized or towed. I cannot miss a shift because some board member with a clipboard decided to reinterpret the site map. Cynthia Moore, Design Review Board Vice Chair, stood between me and the truck with her handheld plate scanner aimed at my rear bumper like she was about to call in an airstrike. She wore a white cardigan with the hood up even though the rain had stopped an hour ago, and her blonde hair was pulled into a sleek low ponytail that did not move when she turned her head. She pointed at the curb 20 feet away. "This is not parking. It is a violation," she said. Her voice had that customer service edge that made every word sound like a threat. "The curb is painted red, fire lane. Your driveway encroaches on the common drive aisle, so you are obstructing emergency access." I looked at the curb. It was not painted red. It was gray concrete, with a single faded yellow line from a street restriping project 2 years ago, and the yellow did not even reach my property line. I told her that. She smiled and tapped her scanner against her palm. "I can make this a lean conversation in one email," she said. The notice in her other hand was printed on neon orange cardstock with a QR code at the bottom and a fine schedule that started at $250. It said I had 72 hours to move the vehicle or face immobilization and towing at owner expense, plus a daily storage fee of $40 and an administrative processing fee of $175. The math did not add up. The timeline made no sense. I asked her when she issued the notice. She said this morning. I checked my watch again. It was 4:15 in the afternoon. She claimed I had been parked in violation since midnight, which meant I had less than 3 days to comply, but she was ordering the tow right now, in front of me, on day 1. The truck driver stepped down from the cab and walked over with a tablet in one hand and the magnetic placard in the other. He showed me the work order. It had Cynthia's signature at the bottom and a note that said, "Authorization granted per board resolution." I asked him what resolution. He shrugged. "Lady called it in," he said. "Your name is on the list." I did not know there was a list. I did not know my driveway was suddenly common area. I bought this house 9 months ago, right after I transferred to the Minneapolis warehouse. The listing said deeded driveway parking, 2 spaces, private. The HOA disclosure packet was 60 pages of rules about lawn height and mailbox paint, but nothing about losing your driveway to a fire lane redesignation. Cynthia folded her arms and told the driver to proceed. He looked at me. I looked at the truck. The wheel lift was already halfway under my rear axle. I raised my voice and told him this was my property and I did not authorize the tow. He stepped back. Cynthia stepped forward. She said the authorization placard was issued by the board and the management company, and that was all he needed. She turned to me and said if I interfered with the tow, she would call the police and add obstruction to the violation report. I felt my chest tighten. I could not miss my shift. I could not afford the fees. I pulled out my phone and took a picture of the curb, the driveway, the truck, and Cynthia holding the scanner. She told me to stop. I kept shooting. She raised the scanner higher and said this was private community property, and I did not have permission to photograph her. I told her she was standing in my driveway. She said the driveway was an easement, and I was trespassing on the approach zone. The driver got back in the cab and started the hydraulic lift. My rear tires came off the ground. I called the police non-emergency line while Cynthia stood there with her arms folded. The dispatcher said it sounded like a civil dispute and they could send an officer for a report, but it would take at least an hour. I did not have an hour. I asked the driver how much to drop the car. He said once the lift engages, the fee is non-refundable. $220 for the partial hook, plus the admin fee Cynthia already mentioned. I did the math in my head. $400 to put my car back on the ground in my own driveway. Cynthia smiled and said the clock was ticking. She tapped her watch. I checked mine. 30 minutes to shift start. I told the driver I would pay the drop fee if he would release the car right now. He hesitated. Cynthia opened her mouth to argue, but a voice from the sidewalk cut her off. That happened to me too, the voice said. I turned and saw my neighbor from 2 doors down, a guy in his 50s with a twins cap and a rain jacket, standing at the edge of my driveway with his phone out. He said Cynthia tried the same thing on him 6 weeks ago. Same truck, same authorization placard, same fire lane story. He paid the fees and then found out the curb was never legally designated as a fire lane. The city planning office told him there was no restricted parking zone on our street, and the HOA had no authority to create one without a traffic study and council approval. He still had the email. Cynthia's face went red. She told him to stay out of it. He ignored her and walked over to me. He showed me his phone. The email was from a city traffic engineer, dated 5 weeks ago, with a PDF attachment showing the official fire lane map for our zip code. Our street was not on it. Cynthia said the map was outdated. My neighbor said he checked with the fire marshal 2 days ago and got the same answer. No fire lane. No restricted zone. Cynthia pivoted and said it did not matter because the driveway was still encroaching on the drive aisle, and that was a separate violation under the architectural guidelines. I asked her to show me the guideline. She said it was in the supplemental standards, which were available by request only. I told her to send me a copy. She said requests had to go through the design review board, and the next meeting was not for 3 weeks. The driver lowered my car back onto the pavement. He said he was not getting in the middle of this, and if we wanted to fight it out, we could do it without his truck. Cynthia tried to argue, but he handed her back the tablet and said the work order was incomplete because the property owner was disputing authorization. He climbed back in the cab and drove off. The amber strobes disappeared around the corner, and the street went quiet except for the sound of water dripping off the trees. Cynthia turned to me and said this was not over. She would file a formal complaint with the board, escalate the fine to $500, and schedule a compliance hearing. She said I had 72 hours to prove my parking was legal, or she would make this a lean conversation in one email. Then she walked away, her scanner swinging at her side and her ponytail bouncing with every step. I thanked my neighbor. His name was Rick, and he said he wished he had fought back harder when it happened to him. He paid $460 total and got nothing but a receipt and a warning letter. He said Cynthia had been targeting people ever since she got elected to the Design Review Board. She used parking enforcement like a weapon. Guest parking, overnight restrictions, fire lane claims, decal requirements that changed every quarter. He said half the neighborhood was afraid to have visitors because Cynthia would walk the streets at night with her scanner and her clipboard, marking tires and photographing plates. He showed me his doorbell camera footage from the night she came to his house. The timestamp was 2 a.m. She was wearing the same white cardigan, standing in his driveway, placing a violation notice under his wiper blade. I asked him if he still had the footage. He said he did, and he would send it to me. I checked my watch. 15 minutes to shift start. I thanked him again, jumped in my car, and drove to work. The shift was a blur. I ran the forklift line for 12 hours, stacking pallets and dodging safety audits, and the whole time I kept thinking about Cynthia and her scanner and the look on her face when the driver pulled away. I got home at 6 a.m. and found another notice on my windshield. This one was printed on pink cardstock and said I was in violation of overnight parking restrictions because my vehicle was parked in the same spot for more than 8 consecutive hours. The fine was $350, and the notice said I had 48 hours to pay or face a lien filing. I looked around. Every house on the block had cars in the driveway. Mine was the only one with a notice. I took a picture of the notice and the empty street and the timestamp on my phone. Then I went inside and started digging through my closing documents. The deed showed my property line extended 5 feet past the driveway edge, which meant my car was parked entirely on my own land. The HOA covenants had a section on parking, but it only restricted street parking and guest overflow. There was nothing about driveway restrictions, nothing about fire lanes, and nothing about 8-hour limits. The architectural guidelines were attached as an appendix, and I read every page. No mention of drive aisle encroachment. No mention of emergency access zones. The only reference to parking was a rule that said all vehicles must be registered and display a current HOA decal. But the decal program had been discontinued 3 years ago, according to a notice buried in the back of the packet. I checked my windshield. No decal. I never got one. I called the management company and got a voicemail that said they were closed for the weekend and would return calls on Monday. I did not sleep. I made coffee and pulled up the county GIS map online. The fire lane overlay showed nothing on my street. The zoning map showed my property as single-family residential with private driveway parking. I downloaded every file I could find and saved them to a folder on my desktop. Then I texted Rick and asked for the doorbell footage. He sent it 5 minutes later, along with a message that said, "Be careful and watch your back." The footage showed Cynthia walking up his driveway at 2:14 in the morning, placing a notice on his windshield, taking a photo with her phone, and walking away. The timestamp was burned into the corner of the video. I watched it 3 times and then saved it to the same folder. I did not mention my evidence yet, because I wanted her to repeat the story first. Monday morning, I got an email from the HOA management company. It said my account had been flagged for multiple parking violations, and my case had been referred to the board for a compliance hearing. The hearing was scheduled for Thursday at 7 in the evening, the one day I had a hard work deadline and could not miss my shift without losing my lead position. I replied and asked to reschedule. The response came back in 10 minutes. Hearing dates are non-negotiable. Failure to appear will result in automatic fine assessment and lien initiation. I called the office and got a receptionist who said she could not help me and I needed to speak to the property manager. The property manager was out until Wednesday. I asked if I could submit evidence in writing. She said evidence had to be presented in person at the hearing, and I had to bring 3 copies of any documents I wanted the board to review. I asked who would be on the board panel. She said the president, the treasurer, and the design review board vice chair. Cynthia. I went to work and told my supervisor I might need to leave early Thursday. He said the shipment deadline was firm, and if I left early, someone else would take the lead. I told him I understood. I did not understand. I understood that Cynthia had timed the hearing to box me in, and I understood that if I skipped it, she would push through the fines and the lien without me there to fight back. I spent the rest of the week gathering documents. I printed the deed, the GIS map, the fire lane overlay, the city engineer email Rick had forwarded, the HOA covenants, and the architectural guidelines. I printed the doorbell footage stills showing Cynthia in Rick's driveway at 2 in the morning. I printed my own photos of the curb and the driveway and the tow truck. I put everything in a folder and made 4 copies, 1 extra just in case. Wednesday afternoon, I got a call from a number I did not recognize. I answered and heard a woman's voice say, "This is Amanda Chen. I am a real estate agent in your neighborhood, and I heard you are having trouble with the HOA." I asked her how she heard. She said Rick told her, and she wanted to warn me what liens and disclosures would do if Cynthia pushed this through. A lien would show up on the title report, and even if I won later and got it released, the record would stay in the system for years. It would kill my resale value and scare off buyers. She said she had 2 listings in Lakeview Crest right now, and both sellers were dealing with bogus HOA claims that tanked their offers. One of them was in a lawsuit. She said Cynthia had been using the design review board to block approvals out of spite, and the management company let her get away with it because they did not want the hassle. Amanda said if I wanted help, she knew an attorney who handled HOA disputes, and she could get me a consult for free. I said yes. The attorney's name was Josh, and he called me that night. He said Cynthia's fire lane claim was garbage, the overnight parking notice was unenforceable, and the lien threat was probably a bluff, but I needed to show up to the hearing and put her on record. He said if she repeated the fire lane story in front of witnesses, I could use it later in small claims court to prove she knew the claim was false. He told me to stay calm, stick to the facts, and do not let her bait me into an argument. He said if she tried to rush the vote, I should demand a continuance and cite the bylaw's provision that said owners had a right to a fair hearing with adequate time to respond. He also said I should record the hearing if the bylaws allowed it. I checked. They did. I charged my phone and set a reminder to start recording the moment I walked in. Thursday came, and I worked until 6:30. I told my supervisor I had an emergency, and I would be back in an hour. He said if I was not back by 8, the lead role was going to someone else. I drove to the clubhouse where the board held meetings and parked in the guest lot. The building was a low brick rectangle with a fake portico and a sign that said Lakeview Crest HOA incorporated in letters too small to read from the street. Inside, the meeting room was set up with a folding table at the front and 3 chairs behind it. Cynthia was already sitting in the middle chair, her scanner on the table in front of her and a stack of papers next to it. The board president, a man in his 60s with wire glasses and a cardigan that matched Cynthia's, sat on her left. The treasurer, a woman with short gray hair and a permanent frown, sat on her right. There were two other people in the room, both owners I recognized from the neighborhood. One of them was Rick. He gave me a nod. I sat down in the front row and pulled out my folder. The president called the meeting to order and said they were here to review a parking violation case involving my property. He asked Cynthia to present her findings. She stood up and pulled a poster board from under the table. It was a blown-up photo of my driveway with red lines drawn over it and a label that said encroachment zone. She said my vehicle was parked in a designated fire lane approach area and that the driveway extended into the common drive aisle in violation of the architectural standards. She said she had issued 2 notices and I had failed to comply with either one. She said the fines totaled $650 and she was recommending an additional penalty of $500 for failure to appear at an earlier informal review. I interrupted and said I was never notified of an informal review. She ignored me and kept talking. She said the board had the authority to place a lien on my property if I did not pay the fines within 10 days, and she was also recommending that my parking privileges be suspended until I submitted a corrective action plan. If you are enjoying this story, hit the like button and subscribe for more wild HOA battles. I raised my hand. The president told me to wait until Cynthia finished. She said the fire lane designation was based on a site plan amendment approved by the board in executive session, and that the amendment had been filed with the county. She said I could request a copy of the filing for a fee of $75. I asked when the amendment was approved. She said that was confidential. I asked how I was supposed to comply with a rule I did not know existed. She said ignorance of the rules was not an excuse, and all owners were responsible for reviewing the governing documents. The treasurer nodded. The president wrote something on a notepad. Rick leaned forward in his chair and said he wanted to speak. The president said the hearing was limited to the property owner. Rick said he was a witness and he had relevant information. The president sighed and told him to keep it brief. Rick stood up and said Cynthia had issued the same violation notice to him 2 months ago, using the same fire lane claim, and he had contacted the city and confirmed there was no fire lane on our street. He said the city engineer sent him a written response, and he had a copy of it with him. He held up his phone. Cynthia said the city's records were outdated, and the HOA had authority to designate fire lanes on private property. Rick said that was not true, and he had also spoken to the fire marshal, who confirmed the HOA had no such authority. Cynthia's face went red again. She said Rick was out of order, and his comments were not relevant to my case. The president told Rick to sit down. I stood up and said I had evidence to present. The president told me to go ahead. I handed him one of my document packets and gave copies to Cynthia and the treasurer. I walked them through the deed, the GIS map, the fire lane overlay, and the city engineer email. I showed them the photos of the curb with no red paint and no fire lane signs. I showed them the HOA covenants with no mention of driveway restrictions. I showed them the architectural guidelines with no definition of drive aisle encroachment. Cynthia flipped through the pages and said none of it mattered because the board had passed the site plan amendment and the amendment superseded the original covenants. I asked her to show me the amendment. She said it was in the executive session minutes, which were confidential. I said if the amendment affected my property rights, I had a right to see it. She said I could file a records request and pay the processing fee. I asked how much. She said $250. The president cleared his throat and said they would take my evidence under advisement and issue a decision within 10 business days. I said I wanted a decision tonight. He said that was not how it worked. I said the bylaws required a fair hearing, with adequate time to respond, and I had not been given adequate time, because the hearing was scheduled on the only night I could not attend without losing my job. Cynthia said I was there now, so the hearing was valid. I said I had to leave in 20 minutes or I would lose my lead position, and I was requesting a continuance. The president said continuances had to be requested in writing at least 5 days in advance. I said I requested it on Monday, and the management company denied it. He said that was their discretion. Rick stood up again. He said the board was violating its own rules, and if they pushed through a decision without giving me a fair chance to respond, he would file a complaint with the state HOA ombudsman. The treasurer said there was no such thing. Rick said there was, and he had already contacted them about his own case. He pulled out a business card and held it up. Cynthia told him to sit down. He did not sit down. He said he had more evidence, and he wanted the board to see it. The president said the hearing was closed to new evidence. Rick said it was not new. It was directly relevant to Cynthia's credibility. He pulled out his phone and queued up the doorbell footage. He said Cynthia had come to his house at 2 a.m. to place a violation notice, and the footage proved she was personally targeting owners instead of enforcing rules fairly. Cynthia said that was a lie. Rick held up his phone and played the video. The room went silent. The footage showed Cynthia walking up the driveway, placing the notice, taking a photo, and leaving. The timestamp was clear. 2:14 in the morning. The president stared at the screen. The treasurer leaned back in her chair. Cynthia said the video was edited, and Rick was trying to sabotage her. Rick said the raw file was on his doorbell camera server, and he could pull the metadata if they wanted proof. Cynthia stood up and said she was not going to sit here and be accused of misconduct. She grabbed her scanner and walked out. The president looked at the treasurer. The treasurer looked at me. The president said they would need to reconvene and review the new evidence before issuing a decision. I said I needed an answer tonight because I could not afford to have a lien filed while they took 10 days to deliberate. He said the earliest they could reconvene was next week. I said that was not acceptable, and if they filed a lien based on a false fire lane claim, I would take them to small claims court and sue for the costs plus damages. Rick said he would testify. The president rubbed his face and said he would talk to the management company and get back to me. I said I wanted it in writing. He said fine. I left the meeting and drove back to work. I made it by 7:55. My supervisor did not say anything, but he did not have to. I kept the lead role, but just barely. The next morning I got an email from the management company. It said the board had voted to suspend the parking violation case pending further review, and no fines or liens would be assessed at this time. It also said Cynthia had requested a special meeting to address procedural concerns, and the meeting was scheduled for the following Tuesday. I did not know what procedural concerns meant, but I knew it was not over. I called Josh, the attorney, and told him what happened. He said the suspension was a win, but I needed to stay on offense. He said if Cynthia tried to reopen the case, I should file a complaint with the management company and demand a third-party review. He also said I should start organizing with other owners who had been targeted. He said the more people who came forward, the harder it would be for the board to ignore the pattern. I called Rick and asked if he knew anyone else. He gave me 3 names. I called all of them. 2 of them had stories just like mine. One of them had paid over $1,000 in fines and fees before giving up. She said she tried to fight it, but the board refused to hear her appeal, and the management company told her to hire a lawyer if she wanted to challenge the decision. She could not afford a lawyer, so she paid. I told her I was not paying, and I was going to make sure everyone who got scammed got their money back. I spent the weekend building a case file. I collected every notice, every email, every photo, every receipt, and every piece of evidence from Rick and the other owners. I printed everything and put it in a binder with tabs and a table of contents. I also printed the county property records and found something interesting. Cynthia's house had a lien filed against it 9 months ago for unpaid HOA dues. The lien was still active. She was not even current on her own dues while lecturing everyone else about compliance. I added the lien record to the binder and highlighted it in yellow. I did not mention my evidence yet, because I wanted her to repeat the story first. Tuesday night, I went to the special meeting. The clubhouse was packed. At least 20 owners showed up, and most of them were people Rick had contacted. Cynthia was not there. The president opened the meeting and said they were here to discuss concerns about parking enforcement policies and board conduct. He said the board took all complaints seriously, and they were committed to fair and transparent governance. Then he said Cynthia had resigned from the design review board effective immediately, and the board was suspending all parking enforcement actions pending a full policy review. The room erupted. People started shouting questions. Someone asked why Cynthia resigned. The president said it was a personnel matter and he could not discuss it. Someone else asked if the fines would be refunded. The president said they were reviewing all recent cases and would issue refunds where appropriate. Rick stood up and asked if the board would commit to an independent audit of the parking enforcement program. The president hesitated. The treasurer said they would consider it. Rick said that was not good enough, and he was calling for a special election to replace the entire board. Half the room applauded. The meeting went on for 2 hours. Owners stood up one by one and told their stories. Predatory towing, fake violations, double fines, harassment, retaliation. One woman said Cynthia had tried to fine her for parking a guest vehicle overnight, even though the guest was her elderly mother, who was staying with her during cancer treatment. Another man said Cynthia had blocked his architectural approval for a new fence because he complained about her at a previous meeting. The pattern was clear. Cynthia had been using her board position to target anyone who challenged her, and the rest of the board had let it happen because they did not want to deal with the backlash. The president said he did not know the extent of the problem until now, and he apologized. He said the board would implement new policies, including a third-party review process for all enforcement actions and a formal complaint procedure with appeal rights. He also said they would hire a new management company to replace the current one, which had failed to provide adequate oversight. Rick said that was a start, but it was not enough. He said the board needed to be held accountable, and the only way to do that was through a board election challenge that flips the power dynamic. He announced he was running for president, and he wanted anyone who cared about fair governance to join him. A dozen hands went up. The election was scheduled for 6 weeks later. In the meantime, the board suspended Cynthia's access to the management portal and revoked her authorization to issue violation notices. They also launched an internal audit of the parking enforcement program and discovered that Cynthia had issued over 200 notices in the past year, and more than half of them were overturned or withdrawn after owners complained. The audit also found that the fire lane designation she had cited was never filed with the county, and the site plan amendment she referenced did not exist. The board was forced to admit that Cynthia had been making up rules and enforcing them as if they were official policy, and the management company had rubber-stamped her decisions without verifying the facts. The fallout was immediate. 3 board members resigned. The management company was fired. And the HOA attorney sent a letter to every owner who had been fined in the past year, offering full refunds and an apology. I got my refund check 2 weeks later, $650 plus a $50 administrative credit for the inconvenience. Rick got his refund too, along with a formal apology letter signed by the new interim board president. But the real payoff came a month later, when the tow company that Cynthia had been using got dropped from the HOA's vendor list after the audit revealed they had been charging inflated fees and splitting the revenue with Cynthia under the table. The company was hit with a class action lawsuit from owners across 3 HOAs, and the state attorney general opened an investigation into their business practices. Cynthia tried to stay quiet, but one of the affected owners filed a small claims suit against her personally, alleging fraud and intentional infliction of emotional distress. I did not sue her, but I did submit a witness statement for the case, and I included the doorbell footage and the lien record showing she was delinquent on her own dues. The case settled out of court, and Cynthia agreed to pay restitution and never serve on an HOA board again. The election happened in early spring. Rick won the presidency by a landslide, and 2 other reformers won seats on the board. Their first act was to pass a new parking policy that eliminated all the predatory enforcement tactics Cynthia had used. No more fire lane claims without city verification. No more overnight parking bans. No more TOW on-site authorizations. No more handheld scanners or clipboard patrols. Guest parking was restored to a reasonable limit, and enforcement would only happen after multiple warnings and a formal hearing with appeal rights. The board also passed a transparency resolution requiring all board actions to be documented and posted online, and all financial records to be available for owner inspection without fees. It was not perfect, but it was a start. I ran into Cynthia one more time, about 2 months after the election. I was filling up at a gas station on the edge of the neighborhood when I saw her white cardigan in the next row of pumps. She was standing beside her car, scrolling through her phone, and she did not see me until I walked over. I did not plan to say anything, but when she looked up and recognized me, I could not resist. I told her I heard the small claims case settled, and I hoped the restitution was worth it. She said I had no idea what I was talking about, and I should mind my own business. I said my business was parking in my own driveway without getting harassed, and thanks to her, the whole neighborhood now had policies to protect them from people like her. She said I was twisting the facts, and the board had overreacted to a few complaints from owners who did not want to follow the rules. I pulled out my phone and queued up the doorbell footage. I said I had video of her placing notices at 2 in the morning, and I had county records showing she was delinquent on her own dues while threatening everyone else with liens. I said if she wanted to keep talking about facts, we could do it right here, or she could walk away and we could both move on. She stared at me for a long moment, her face red and her jaw tight. Then she got in her car and drove off. Rick called me a week later and said the new board had voted to issue automatic refunds to everyone hit in the enforcement wave. The refunds covered not just the fines, but also the tow fees, the immobilization fees, and the administrative processing fees that the old management company had been charging. The total came to over $40,000 across 60 owners. The money came out of the HOA's reserve fund, which meant the next special assessment would be higher. But the board decided it was worth it to make things right. Rick also said the HOA attorney had been replaced, and the new attorney had sent a formal demand letter to the old management company, asking them to reimburse the HOA for all the bogus enforcement costs. The management company settled for $30,000 to avoid a lawsuit, which helped offset the reserve fund hit. It was not a perfect outcome, but it was something. The funny thing was, Cynthia had insisted it was a fire lane issue, and the actual curb markings and ordinance proved she was wrong. The city had never designated our street as a fire lane, and the fire marshal confirmed in writing that the HOA had no authority to create one without approval. The HOA lost in small claims court when one of the owners sued for the fees, and the judge ruled that the enforcement was baseless and the HOA had to pay costs. Cynthia got corrected by the HOA attorney in plain language during a closed-door meeting, where the attorney told her she had exposed the association to massive liability, and if she did not resign immediately, the board would vote to remove her and file a formal complaint with the state. She resigned the next day. I still live in Lakeview Crest. The new board is not perfect, but they are honest, and they listen. Parking enforcement is fair now, and the predatory vendor is gone. My driveway is still my driveway, and I have never had another notice on my windshield. Rick is doing a good job as president, and the neighborhood feels different. People are not afraid to have guests over anymore. They are not afraid to complain when something is wrong. And when the board makes a mistake, they fix it instead of doubling down. It is not the HOA I signed up for when I bought the house, but it is the HOA I helped build. And that is enough. I hope you enjoyed this wild HOA mess.